If you have a controversial estate plan, in other words, one type of controversial estate plan is if you're disinheriting somebody who would benefit if there were no will. In other words, you want to disinherit a spouse or a child. Keep in mind that the probate process is an opportunity for people to come in and complain. So let's review that a second. If you don't have a revocable living trust, that means your executor needs to take the will down to the probate court and apply to the court, asking the court to find that this document, the will, is actually your last will and testament. And before the court does that, it will require that notices are sent to all the people who would inherit your property if there were no will. So that means when the will gets presented to the probate court, all your children will receive a notice. Your spouse, your surviving spouse, will receive a notice. That's assuming you have a spouse and children. If you don't, then the statutes would identify the people who would get notice. In any event, all of these people get notice, and if you've disinherited one of them, they're likely to be a little bit upset about that. When they get the notice, it's an opportunity. It would typically say the will has been submitted to the probate court and the court's been asked to admit it to probate, and it will do so unless it hears from you within a certain period of time by a certain date. That is an invitation for them to come in and complain if the will has disinherited them. On the other hand, that's part of the probate process. If you avoid probate, there's not a notice requirement of that sort. There's no process whereby before the trust is effective, it needs the blessing of the court. So with a revocable living trust, everything's already in place. And if a person wants to complain about it, that person is put in a position where he has to attack something that already exists when you have a revocable living trust. When you have a will situation, that person is put in a position where he's contesting something that hasn't happened yet. He's preventing something from beginning instead of attacking something that's already in place. So it's two different types of positions to be in. One you can do in the probate court, which is a much easier place to complain. And the other you can only do in the superior court, which is a regular lawsuit, which is much more expensive. So if you've got a revocable living trust, the place to attack for a disgruntled beneficiary to attack that would be in the superior court. If you don't have a revocable living trust and everything's done by a will, then the place to attack that would be in the probate court. So if your planning is done through a revocable living trust, it's much less likely that unhappy family members, unhappy heirs, would attempt frivolous claims. It's much easier to pursue a frivolous claim in the probate court than it would be to start a lawsuit in the superior court. We talked about a situation where you may be supporting other people. You're alive and well, and you're supporting other people, and you're concerned that your incapacity will disrupt that support. And the revocable living trust can be a good way to make certain that in the event of your incapacity, the support that you're giving to others will not be disrupted. And of course, the process of doing a revocable living trust and all the work that goes into it, especially the process of retitling your assets so that all your assets are owned by the revocable living trust, that can make life simpler for your beneficiaries and for your survivors. Because at your death, all the work of collecting the assets is already done. They're already in the hands of the trustee, and the trustee doesn't have to go through that process of figuring out where everything is. He already knows where everything is because it's already in the trustee's name. On the other hand, the executor who's appointed under the will doesn't have possession of anything. Part of his job is to go out and identify all the assets and taking possession. So how simple it is would depend on how organized you are and what kind of records you leave behind at the time of your death. But it still can be a great unknown to the executor. Where are the assets? How do I go collect them? How do I identify them? It's a big puzzle, and the executor feels compelled to pay attention to a lot of details that may be irrelevant. You never know when there's going to be a clue that an asset exists. So you're looking at every piece of paper that's in the decedent's house and looking for clues. So the executor's job at that beginning stage is daunting. And if you have a revocable living trust and you organize that all beforehand and put it in the hands of the trustee beforehand, obviously that can create a much simpler situation for the trustee and the survivors. Another way that revocable living trust can make things simpler is sometimes we've had clients who have had children who they just have no idea where these children are. They might have been children from a previous marriage that was when they were very, very young, and a messy fact pattern, and the child has just not been a part of the client's life, and nobody knows where the child is. Keep in mind, part of the probate process is sending a notice to that child, and if the child can't be found, that makes it difficult to proceed. So to avoid that type of situation, you might want to avoid probate and have your estate settlement done through a revocable living trust. It's very common for us to see clients who've already heard something about revocable living trusts, and they come in with the impression that if they don't do a revocable living trust, they're going to have to pay up to 50% of their estates and estate taxes when they die, and that the only way to save taxes is through a revocable living trust. And they hear other things about revocable living trust too. So I wanted to list the non-reasons for considering revocable living trust, because some of these impressions that clients come in with are just plain wrong. And the claim that a revocable living trust is necessary to save estate taxes and income taxes is false. It's false. What's true is revocable living trusts are really tax neutral. Everything that you can do to save estate taxes in a revocable living trust, you can do with a will. And everything you can do in a will to save estate taxes, you can do in a revocable living trust.
This is a chart that shows how the probate court fees in Connecticut are calculated. And this is true whether or not probate is avoided, because, as I've said before, the probate court fees are based on the size of the estate for estate tax purposes. You can see that for a $500,000 estate, the probate court fee is a little bit more than $1,800 plus 1/4% for each dollar above $500,000 until you get to $2 million, when the rate is increased to 1/2%. When the size of the estate gets to $8,877,000, the probate court fee is capped at $40,000. The $40,000 cap was made effective July 1, 2016, after an uproar resulted when previous legislation removed the cap. The capless system lasted for 1 year until July 1, 2016, when a cap was reinstated at $40,000.
That's all we have to say for revocable trust and probate avoidance for now. In our next segment, we'll talk about gift planning.